You know that moment in a courtroom drama, right? The last minute bombshell, a surprise witness, a hidden document that just blows the case wide open? Well, what if I told you that in a real civil trial, that kind of thing is almost always forbidden? Today, we're going to pull back the curtain on the hidden rules of evidence, and you'll see it's less about those dramatic reveals and way more about a very strategic and super strict game. See, while Hollywood absolutely loves chaos, real courtrooms are all about order. There's a really tightly controlled sequence for pretty much everything, especially when it comes to presenting evidence. And this isn't just about being neat and tidy, it's about making sure everything is fair and preventing one side from totally ambushing the other. So that brings us to the big question, doesn't it? If you have a piece of evidence that could literally win your case, why on earth would you be stopped from using it whenever you want? Well, the answer is all about preventing a very specific and very unfair tactic. And here it is. The villain of our story is something called case splitting. Just imagine this. You present your main argument, but you intentionally, and this is key, you intentionally hold back your most powerful piece of evidence. You just sit there, you wait for your opponent to lay out their entire defense, and then, bam, you hit them with the evidence they had absolutely no chance to prepare for. The courts see this as a procedural ambush, and it is a big, big no-no. So to stop that from happening, the legal system has this really important rule that basically governs the flow of a trial. It's all about when you get to speak, and maybe even more importantly, what you're allowed to say when you do. Okay, so after you've presented your main case, you get another turn. It's called a rebuttal. But, and this is a huge but, any evidence you present then has to be strictly in reply. Think of it like a card game, right? You've got to play your main hand first. You can't just see what your opponent plays and then suddenly pull an ace out of your sleeve that honestly you could have played from the very beginning. Your rebuttal is only for responding directly to the new cards they just put on the table. Let's break this down to make it super clear. You can't use your rebuttal time to just add more proof you forgot to mention the first time around. That's just trying to bolster your original story, and that ship has sailed. No, rebuttal is a defensive move. It's your one shot to directly challenge a new point, or a surprise bit of evidence that your opponent just brought up. But, it's not always so black and white. Even with this really strict rule, courts in civil cases are often a lot more flexible than in criminal ones. A judge has what's called discretion. And this quote here shows that if a lawyer makes a simple mistake or just forgets something, a judge will often let them fix it. The goal isn't to play gotcha and win on a technicality. And this flexibility is so important because it opens the door to some really fascinating exceptions. These moments where the rules get bent, but for a very good reason. So why even have these exceptions? Well, it's because the legal system gets that its real purpose, its ultimate goal, is to find the truth and get to a just result. Rigid rules are great, they're useful, but they can't become a straitjacket. These exceptions are like safety valves, making sure that fairness always wins out over just sticking to the procedure. So how does a rule get bent? Well, there are basically 4 main ways. First, if you are misled about a witness they were going to call. Second, and this one's a big deal, if the burden of proof is actually on your opponent for a certain issue, you get a lot more freedom to respond. Third, if they present evidence that was just truly out of left field, totally unforeseeable, you get a chance to answer it. And finally, you've got the ultimate safety net. A judge can always let evidence in if it's simply in the interest of justice. Okay, so what in the world does in the interest of justice actually mean? It's a pretty broad category, right? It can cover everything from clearing up an honest mistake to allowing brand new, fresh evidence that was just discovered. It's like a lifeline for a lawyer who made a genuine error, but definitely not for a sneaky tactic that just backfired. And this power is so big that in really, really rare cases, a judge can even admit new evidence after a judgment has already been made. Wild. All right, let's take all these rules and apply them to a more complicated, real-world gray area. This is where the theory starts to get a little messy. Picture this, a simple car accident. The plaintiff, that's the person suing, has to prove the other driver, the defendant, was negligent. But then the defendant fires back and says, "Whoa, hold on a second, you are at fault too." This is a claim of contributory negligence. And now, all of a sudden, we have 2 competing claims on the table. And here's where it gets really complicated. The plaintiff has the job, the burden, of proving the defendant was negligent, but at the exact same time, the defendant has the burden of proving that the plaintiff was also negligent. Each side has a separate thing they have to prove to the court. So here is the giant dilemma. The exact same facts, the speed of the cars, the road conditions, who had the right of way, that evidence is often used to prove both claims. So how can the plaintiff possibly hold back evidence to rebut the defendant's claim later without being accused of splitting their case? It is a classic legal catch-22. It's a real pickle. And this whole problem, this dilemma, it brings us to the core tension that's really at the heart of our entire legal system. It's this constant balancing act between two competing ideas. What this all shows is this ongoing tug of war in the law. On one side, you absolutely need strict, predictable rules. That's how you get fairness and order. But on the other side, the whole point of the system is the pursuit of truth. And let's be honest, the truth is often messy and unpredictable. And this rule against case splitting, it lives right on that fault line between the two. And this quote from a judge, oh man, it just perfectly captures the paradox. He's pointing out that courts are often super lenient about letting lawyers change their official paperwork, even in the middle of a trial. And yet they can be incredibly restrictive, almost stubborn when it comes to admitting a piece of evidence that's just a minute too late. He calls it a curious discrepancy, and it shows you just how tricky this balancing act really is. And so this leaves us with the big question to chew on. By forcing everyone to follow these really strict procedural rules to prevent an ambush, are we actually creating a fairer system? Or are we sometimes preventing relevant, truthful evidence from ever seeing the light of day? It's a fundamental question about what we want our justice system to be about: predictability or truth.